Hi, good morning, ma'am. Can you hear me? The person who has party on Abilene, can you hear me?
Yes, I can. I'm sorry. I can hear you.
That's okay. What's your name, please?
My name is Crystal Scott.
Thank you.
I hear you, but I don't see you, the judge.
Nope, I'm not the judge. That's fine. Yeah, you won't see me.
Okay.
Hold on. She'll be out. Everything starts at 9 o'clock.
Okay.
Great. Thank
Just
you.
trying to get in early like you asked.
That's great. Good morning, Miss Samples. How are you?
Good morning. I'm good. How about you?
I'm well. Thank you.
Awesome.
Good. We'll start in a little bit, okay?
Thank you.
Thanks. Good morning, ma'am, who just signed on with the purple turtleneck. Can you hear me? Ma'am, can you hear me? You have the glasses?
Are you talking about me with the blonde hair?
Oh, no, I already have your name. No.
Okay, great. I'm sorry.
Good morning. This is Wednesday, November 17, 2021. I am Judge Martin. Today is the landlord-tenant docket. If you do not have a landlord-tenant case, you are in the wrong courtroom. You should check your notice and log in the correct place. We have approximately 20 cases scheduled, all at 9 o'clock, so please listen for your name to be called. If it is not your hearing time, please mute yourself. Thank you very much. Mary Ann,
I was dreading this question.
why are you dreading this question? There's no dreading.
I don't have a positive answer. No, there are no matches yet, Judge.
There are no answers? There's always answers. What are
No
you talking
matches.
about?
Matches.
We have no matches? How is
No.
that even possible? Everyone is in and everyone is named?
Except for this iPad person, couldn't hear me
Let's
earlier.
see if we can figure out who this is.
I'll send a chat, hopefully.
Nope, she's ready with a glasses and looks like something with a drawstring. Your name,
Yeah.
ma'am?
My name's Terry Sant. I'm the owner of Brookdale Farms, where Darius is at. Brookdale Farms. Steve Robinson is my lawyer.
I see it. I haven't seen Mr. Robinson yet, but I see Mr. Carr. So as soon as Mr.
Yeah.
Robinson logs on, we'll get going. Thank you, ma'am.
Okay, thank you.
Mr. Shervinnik,
Good morning, Your Honor.
good morning. Who are you here for?
I'm appearing on behalf of the plaintiff, the Secretary of Veterans Affairs.
Thank you, sir. And here Mr. Carter is. Good morning, officer. I am wonderful. How are you?
Was I hearing things, or did you tell me yesterday that there's a possibility that one may come in?
There should be 2, 4, 6, 8, 10 people coming in this morning, but they don't read the notice that tells them to appear in person.
So it could be 10, it could be 0.
It could be 10, it could be 0.
Okay.
Anything else going on this morning?
We got exams starting at 11.
We have a 9 o'clock docket. I have my first match set, so if we need you, I'll call you, but I don't imagine that we have too much going on.
I know we put Krauts in the downstairs. Harry Kraut and Sandy Kraut.
Downstairs for what?
They must have, they got some kind of civil case going.
Mary Ann, remind me that Ms. Zannon goes last. I don't care if nothing else is going on. She'll go dead last, please. Thank you.
Okay.
Thank you, ma'am. Mr. Robinson's here, but we have a match set with Mr. Carter. Dennis Carter. What happened to him?
He's here. He just didn't.
He lost his audio. Okay. Good morning, Mr. Robinson.
Morning, Judge.
Your client as well as Mr. Carr are here. Are you ready to proceed this morning, sir?
We are, Your Honor.
Thank you. This is 214740 LT, Brookdale Farms versus Adarius Carr. Appearances, please.
Good morning. Excuse me. Good morning, Your Honor. For the record, Steve Robinson appearing on behalf of Brookdale Farms.
State your name for me, Mr. Carr.
Adarius Carr.
Thank you. Today is the day and time set for the second hearing in this matter. The parties both appeared on November 10th, and there must not have been a resolution for it to be put over on my docket. Mr. Robinson, how are we proceeding this morning?
Your Honor, I'm sorry, Judge.
I'm sorry, hold on one second. Taylor, I have no ROAs in the files, and I know I only have 4 or 5 up here. If I send Officer Brooks down, could you hand him a stack of ROAs, please?
Yep, sorry.
Thank you. No worries. I'm sorry, Mr. Robinson. You were saying?
Yes, Judge, it's my understanding that the.
Oh, I'm sorry. I'm sorry. Taylor, never mind, not ROAs, the blue forms, and I have enough. Never mind, they're just not hole punched.
Okay.
Mr. Robinson, I interrupted you for the last time. I'm sorry.
That's okay, Judge. At the pretrial, Mr. Carr had indicated that essentially I guess he doesn't live there anymore, that he had a roommate and the roommate is there, which I guess we tried explaining to him that it really doesn't matter because the lease is in his name. So I don't think there's any dispute as to the amount of rent that's owed. That's where we're at. Is that a fair assessment, Mr. Carr?
Correct.
Okay.
Mr. Carr,
Yes, ma'am.
you are not at 46570 Willis Road, lot 27?
No, I left, I got my stuff after I got the first notice of possession. Because I got a note stating that they're demanding possession of the trailer. So it said on the paper that I had 7 days to either pay the amount or to move out. So I got my stuff.
I'm sorry, Mr. Carr, I didn't mean to cut you off. There is a summons and a complaint in the file dated September 30th, 2021 that lists rent due as $1,434. Mr. Robinson, how much rent is currently due?
The total amount due is $2148, Judge.
Mr. Carr, is that an accurate amount that's due and owing?
Correct.
Do you dispute that amount in any way, sir?
No, I do not.
Thank you. So, Mr. Robinson, how are we proceeding?
Your Honor, based on the admissions, but although Mr. Carr was not under oath, but based on his admissions, I just asked for a judgment of possession, writ to issue. I think, Judge, the 29th, I think, is the writ date.
Mr. Carr?
I'm sorry. What did you say?
Did you hear what Mr. Robinson just said regarding the amount of rent that's due $2,148?
Yes.
Do you dispute that amount in any way?
No.
Your Honor?
Mr. Carr, have you applied for financial assistance or did you need financial assistance to pay this amount?
I have got the serum started for this case.
You have?
Yes, I have started it. Yes,
Do you have a SARA number, sir?
I do. It's 433636.
Mr. Robinson, inasmuch as Mr. Carr has made an application for SARA funds, that changes the posture of this case quite a bit. Mr. Carr, this court is required to enter a stay of these proceedings as you have applied for financial assistance. What will happen next is you'll receive a notice from the court indicating that there is a stay in place pursuant to Administrative Order 2020-17. That stay will remain in place until such time as either the parties sign a stipulated agreement resolving the matter or this court receives a request from plaintiff to lift the stay because SARA funding has not paid the past due balance or they have received notice that you do not qualify for some reason. Understood?
Understood.
Yeah,
Okay.
Judge, if I may, Mr. Carr, is it your intention or desire that you wish to stay there?
That is my intention.
Okay, that's fine. That's fine. That's all I need to know.
Yeah.
Anything else, Mr. Robinson?
Yeah, Judge, I didn't get the full Sarah number. If you could repeat that for me again, Mr. Carr.
It's
433-636.
Steve,
Yeah,
Adarius told me that the guy that's living in there is the one that applied for this, and Adarius has no plans to be living there at all. And that gentleman has been.
No,
working the
I'm
whole-
sorry, ma'am. That's a
Mhm.
conversation for you and Mr. Robinson to have
Okay,
offline.
sorry.
We have a
Okay.
tenant who has presented themselves, the only named party who has presented themselves and indicated they've applied for Sarah funding. If you, Mr. Robinson and Mr. Carr wish to have conversation regarding the pending application, Mary Ann will put you into a breakout room. But inasmuch as he's indicated the application, this court is staying the proceeding.
okay. Could we go in the breakout room, Judge?
Absolutely, Mary Ann will facilitate that right now.
Thank you.
Thank you.
Thank you.
Adarius, that's what you told me, right?
Dennis Carter.
Oh, sorry.
Yes, ma'am. Yes, ma'am.
Mr. Carter, please remove your cap. Will Rachel Carter be joining us, sir?
My wife got lupus. So she's sick. She's bedridden.
Okay, Mr. Carter.
She's here.
This is
She's here.
Okay,
She's
sir,
here.
it's, okay. I just asked was she joining us. I'm with you. This is 214-660 LT, Secretary of Veterans Affairs versus Dennis Carter and Rachel Carter. May I have your appearances, please?
Good morning, Your Honor. Timothy Shervanack, P71136, appearing on behalf of the plaintiff.
State your name, Mr. Carter.
Dennis Carter.
Thank you. Today is the
my
day and
wife,
time set
Rachel.
for the, thank you. Set for the second hearing in this matter. The parties appeared with my resolve on November 3rd, 2021, did not reach an agreement. How are we proceeding this morning?
Your Honor, this is a termination of tenancy case following a mortgage foreclosure. We're requesting a judgment of possession be entered today. I do have authority I can offer beyond the typical 10-day judgment date.
Mr. Carter,
Yes, ma'am.
do you intend to represent yourself this morning, or have you sought the assistance of an attorney to provide assistance in this matter?
Yeah, the last hearing we had, you guys recommended somebody to the VA. And I did talk to that attorney, and everything was handled like it was supposed to be handled. So therefore I reached out for another residence, and I can move in that residence in 14 days.
Okay, Mr. Carter, what I'm going to do is have you go into a breakout room with the attorney for the
Okay.
Secretary of Veterans Affairs. By
Okay.
law, there's 10 days to move from the residence, but he's indicated that he is able to negotiate more time. So if
Okay.
you go in there and he's able to give you the time you need to move, we can have a conversation about a consent agreement for you to move within that time, or figure out what our next steps will be, okay?
Yes, ma'am.
Thank you, sir. Look for the invitation to join the breakout room.
Thank you.
Mr. Carr, did you ever go into the breakout room with Mr. Robinson?
No, I didn't get an invitation.
Mary Ann's going to put another invitation up for you to go into breakout room number 1.
Thank you,
Okay.
Judge.
Perfect, thank you.
Thank you. Crystal Scott, 214709 LT, West Village Estates versus Crystal Scott.
Yes, I'm here.
I was just invited to go into a breakout room with Miss Scott. This is Jarrett Levine, Scott, for the plaintiff.
Were you looking to go into a breakout room with her, Mr. Levine?
Yeah, it'd probably be a good idea. We talk. I always like to talk first. And we have, it looks like we have room 3 joined.
Ms. Scott, would you please join Mr. Levine in breakout room number 3?
Thank you.
So click
Thank
where
you.
it says join the breakout rooms, right?
Yes, ma'am.
Okay, thank you.
Ms. Zanin, this court did receive the dismissal of 214773 LT Bellvilla versus William Banfield.
Okay. The only one that I
And we
show,
have,
I apologize, Judge. The only one I show still up is Bella Vista versus Spence, Emily Spence.
correct. I have not seen anyone by the name of Spence. We don't have any unidentified persons in our breakout room. This is 214770 LT Bellvilla Meadows versus Emily Spence. Have your appearance, please, ma'am.
Good morning, Your Honor. Carrie Zanin, P67390 on behalf of the plaintiff.
As indicated, today is the day and time set for the second hearing in this matter. It was scheduled for 9 o'clock. It is now 9:14 a.m. by the court's clock. There are no unidentified persons in the court's virtual waiting room. Notice was mailed to the defendant to appear. She had previously appeared at the first hearing on November 10th, 2021. Ms. Zanin, inasmuch as defendant has failed to appear for the duly scheduled hearing in this matter, how do you wish to proceed?
Your Honor, you know, Mr. Landau prepared a conditional dismissal, and I'm willing to do that even though she has failed to appear. The terms are with rent to retain $2,386.22. This is due through November 10th, so it's a little late. I don't know if you would rather just take a default judgment. I can do that. I can do either way.
Inasmuch as Ms. Spence is not here to execute the conditional dismissal, or would prefer default judgment, and you said rent to retain is $2,386.22?
No, actually, it's since the date of that conditional dismissal, I'm showing $2,436.22 plus court costs of $155. So total rent to retain $2,591.22, Your Honor.
Thank you. Again, this matter was scheduled for 9 o'clock. It's now 9:15 by the court's clock. Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $2,436.22, $155 in court costs, for a total of $2,591.22. Ms. Zanin, will your office submit the default judgment by email, please?
I will. Yes, Your Honor.
Thank you so very much, ma'am. That's all I have for you this morning, unless you're showing something else.
I don't have anything else, Your Honor. Have a great day.
Thank you, ma'am. Have a good day.
Bye-bye.
Thank you. It's
Kayla
my.
said again, she's sorry.
No.
She's ready to cry.
Why?
I told her, I said,
Don't
worry about it.
cry.
Judge is not mad.
No,
She
No.
said it was a bad day yesterday.
no, it's not a bad day.
I just told her, don't worry about it.
I don't get mad. I'm mad at myself that I looked at the files yesterday and didn't realize. I knew there were no ROAs. I wasn't paying attention to the blue forms because my notes are. Taylor, don't be upset. I'm not mad at all, ma'am. Not at all.
I'm sorry.
No, don't listen. Don't apologize. I am not mad. It is just paper. It's only 9:17 on my 9 o'clock docket. If the worst thing that happens today is no blue forms, we've had a pretty good day, I think.
All right, thanks.
Mr. Carter and Mr. Chavanik are back on 214660. Did you come out of the breakout room or were you kicked out?
We came out, Judge, since we were able to quickly come to an agreement.
And the agreement is?
The agreement is, it would be just a judgment of possession only, and the writ to issue after December 6th, which Mr. Carter said would be plenty of time for him to move out and be able to move his belongings to his new residence.
Mr. Carter, you were able to hear what the attorney just placed on the record?
Absolutely, yeah.
And it's your understanding and agreement that you will move from the property at issue here on or before December 6, 2021?
Yes, ma'am.
Are you sure that will give you and Mrs. Carter sufficient time to move into the new residence?
Yes, ma'am.
Okay. And are you going to sign and send, are you going to send the consent judgment to Mr. and Mrs. Carter for signature? Or did you discuss that in the breakout room, how you would effectuate that, sir?
No, we did not discuss that. I can, if he wants me to sign with his permission, or I can forward it to him, whatever his preference is.
Yes, you can sign. You can sign.
Okay,
We good. We all right. God is blessing us. We okay. Go ahead and sign it. And we're gonna go on ahead and move forward with what we gotta do in life. That's what we're gonna do.
okay,
And
very
Mr.
good.
Carter, you've indicated that Mrs. Carter is present but
Yeah, I can
unwell.
let you speak with her if you want to get her okay. She's just in the bed, but she can't speak.
Mr. Carter, the thing is, we are recording these proceedings and they're running live on YouTube. So I don't know that your wife necessarily wants the world to see her in the bed.
Okay.
It's your preference. I like to make people aware of the fact that we are streaming these proceedings.
Okay. Let's be quick. We can do this quick. Babe, you just need your okay from the judge. This is
Good morning,
Miss Rachel.
ma'am.
Hi, good morning.
Your name, please?
Rachel Carter.
Ms. Carter, we've had some conversation this morning regarding the property where this termination of tenancy case is based. Mr. Carter has indicated that you will agree to move from the property on or before December 6, 2021.
Yes.
And you're okay with the attorney signing the judgment that indicates that you will move on or before December 6, 2021?
Yes.
Thank you so very much, ma'am. Mr. Carter, once this court receives the signed consent judgment from the attorney, we will sign it, send copies to everyone involved, okay?
Yes, ma'am. Appreciate that.
Anything else in this matter on behalf of plaintiff?
Your Honor, I'm not familiar with this court's procedures regarding forwarding judgments. What method would be the best way, email or fax?
Email to civil@34thdistrictcourt-mi.org, and they'll send it up to me and I'll sign it and I'll get it back over to you.
Okay, very good.
Anything else, sir?
No, Your Honor.
Anything else, Mr. Carter?
No, ma'am. Thank you for your
Thank you so
day.
much,
Stay
sir. Have a
safe.
good day.
Bless.
Thank you.
Thank you. Mr. Robinson and Mr. Carr, you're back.
Judge, we never went back in. So,
Mary Ann will try it again.
okay, thank you.
Thank you. Mr. Levine is still gone. Miss Miller. Have we seen the Sylvius yet? I do not see them. Give me one moment. This is 214822LT. This is HP Foreclosure Solution versus Clifford C. Sylvia Jr. and Susan L. Sylvia. This matter is scheduled for the second hearing on this termination of tenancy matter. May I have your appearance, please, ma'am?
Stacia Miller on behalf of plaintiff P81599.
As indicated, today is its day and time set for the second hearing in this matter. First hearing was November 10th, 2021, at which time the defendants failed to appear. The matter was scheduled for hearing today at 9 o'clock. The defendants were to be here in person. There is no one in this courtroom on this matter. There is no one in the court's Zoom room indicating that they're here for this matter. Again, scheduled at 9 o'clock. It's now 9:22 a.m. by the court's clock. Defendants having failed to appear, ma'am, how do you wish to proceed?
We would like to enter the default judgment of termination of tenancy, please, possession only. Excuse me.
Thank you. Again, inasmuch as the defendants have failed to appear, this court will enter default judgment possession only in favor of plaintiff and against defendant. Ms. Miller, if you would be so kind as to email that default judgment to the address that appears in the chat. The civil department will send it up to me for signature. Anything else, Ms. Miller?
Not on this matter. I have another matter in front of you when you're ready.
I am. Give me 1 second. This is 214834 LT, Redford LLC versus James Nemeth. Again, today is the day and time set for the second hearing in this matter. The first hearing was on November 10th, 2021, at which time the defendant failed to appear. Notice would have been sent to the defendant to appear in person at the court this morning. There is no one in the court's actual waiting room, no identified persons in the court's virtual waiting room, no one in the court's Zoom room on this matter. Scheduled for 9 o'clock. It is now 9:24 a.m. by the court's clock. Defendant having failed to appear, Ms. Miller, this court has noted your appearance. How do you wish to proceed?
Again, another default judgment, termination of tenancy, possession only, please.
Thank you. Default judgment shall enter in favor of plaintiff and against defendant for possession only. Plaintiff's attorney to submit the default judgment to the court by email. Believe that concludes your docket with the court this morning, ma'am.
It does. Have a wonderful day, Your Honor. Thank you.
Thank you, ma'am. You too. Thank you, Mary Ann. This is 213354 LT, Rawsonville Woods versus Aaron Allen Browder and Tiani Jackson.
Good morning, Your Honor. Robin Maccabee, P 64575 of Pallets Law on behalf of the plaintiff. We have been informed.
Ms. Maccabee, this court has received a communication from the secretary indicating that your office will be dismissing this matter.
That's correct, Your Honor. We recently received information this morning from our client that the SERA funds have been received and were received late last night.
Matter was scheduled for 9 o'clock. It's now 9:25 a.m. Defendants have failed to appear. Plaintiff's attorney has indicated that SERA funds were received and this matter will be dismissed. Ma'am, if your office would be so kind as to submit the dismissal by email, court will sign it and get it back to the parties as quickly as possible.
Yes, we will, Your Honor. Thank you.
Thank you much. Mr. Robinson.
Yes, Judge, I had an opportunity to speak with Mr. Carr, and he stated that he didn't apply for the SERA, it's the roommate. The roommate's not on the lease. So, and it's my understanding that his intention is that the roommate's also going to be leaving, which may be a totally moot issue, but I don't know how this person can apply when they don't even have a lease, and the tenant has not applied, so.
Your Honor?
Hold on. This is 214740 LT. Mr. Robinson, I was just asking why you were back. I didn't expect you to launch into, I'm with you though. Mr. Carr, that's okay. Mr. Carr is now back. And Mr. Carr, the court asked previously if you had applied for financial assistance in this matter. You indicated that a SERA application had been made. Mr. Robinson has indicated that that SERA application was filed by someone else.
So yes, my roommate is staying in the house.
Your Honor, if I may appear in a limited capacity on Mr. Carr's behalf, I provided him with legal advice in the mediation room.
You provided him with legal advice when the parties were here a week ago?
Yes.
Ms. Cooper, I appreciate your desire to assist in this matter, but you provided him with legal assistance at the first hearing, and how are you indicating the parties should proceed this morning?
So anyone who is a resident or who is residing in the home can apply for SERA funding. And so although Mr. Carr has vacated the premises, because his roommate is still residing in the premises, they can apply for SERA, and Wayne Metro will still provide the SERA funding for the rent arrears. And so that was the advice that I gave Mr. Carr, to have his roommate apply for SERA funding.
This court had previously indicated that a stay would be in place based on the application for SARA funding. It will remain in place until such time as either the parties reach a resolution or plaintiff or the court receives a request from plaintiff to lift the stay because I said at the time the defendant is not eligible, but the property is not eligible for SARA funding. Ms. Cooper, is any information that you gave Mr. Carr suggest a different result of this hearing this morning?
No, they will, so basically the terms for MISTA is that someone has to be residing in the home for them to provide SARA funding. And because the roommate is still residing in the home, they will provide the SARA funding for the rental arrears.
But Mr. Carr doesn't want them to be living there.
And Ms. Cooper, I appreciate your assistance. And as I indicated, this court has already put a stay in place based on the fact that there is a SARA application for the property. So my question was, does the information you just gave regarding MISTA, does that change the posture of the case in any way, shape, or form?
No, Your Honor.
Okay. Mr. Robinson, as previously indicated, the SARA application for the property does stay the proceedings. If something changes, you are more than welcome to submit the request to lift the stay, but the next step in these proceedings is that the civil department will mail a copy of the stay to you and to Mr. Carr. Anything else this morning in this matter, Mr. Robinson?
No, Your Honor.
Anything else, Mr. Carr?
No.
You just muted yourself. You're fine. Thank you very much. We're all set. Have a good day.
Thank you as well.
Thank you. Mr. Levine and Ms. Scott, 214709. Was that sufficient time in the breakout room?
Yes.
Yes?
Yes, it was. Thank you.
How are we proceeding in this matter?
Miss Scott has an appointment with Sarah set for Friday. And there's still an arrearage, a pretty significant arrearage that goes back to June with NSF. But she has an appointment set for Friday. So that's where she doesn't have an application in yet. She has an appointment. Apparently there was some difficulty trying to get her application in.
Ms. Scott, were you able to hear Mr. Levine just now?
Yes, I was.
And is it accurate that you have an appointment on Friday, but you have not yet filed an application?
Correct.
So, Mr. Levine, are you suggesting that we stay these proceedings, or are you looking for an adjournment of today's hearing?
I'm not suggesting that we stay. I might follow the court's direction. There is an appointment Friday. I'd like to see how that comes out. Maybe an adjournment and see if she can get the application in a week, but that puts us into Thanksgiving. A week if the court can accommodate us, or two.
It won't be a 1 week adjournment. It'll be 2 weeks. It'll be December 1st, 2021 at 9 a.m. I do believe. Let me just double check. Miss Scott, would you be available on December 1st at 9 a.m.?
Yes. What day of the week is that?
So Wednesday, ma'am.
Yes, I'm available. December 1st at 9 a.m.
Mr. Levine, Ms. Scott, we'll see you back here December 1st at
Thank you.
9 a.m. Ms. Scott, if you are able to successfully submit an application for SARA funding, what you should do is contact plaintiffs to let them know so that we can enter the stay of the matter versus having the parties appear just to put the stay on the record.
So when I let
If
them
for
know
some
that,
reason, I'm sorry?
go ahead.
I was gonna say, if for some reason the application is not made, please be prepared to have a hearing on this non-payment of rent matter on December 1st at 9 a.m.
Okay, but if I'm able to fill out the application, then we won't have to come to court?
You'll get the SARA number and you should relay that to Mr. Levine's office. Because the SARA application will stay the proceedings versus having the parties come just to say, Your Honor, we did do the application and the matter will be stayed. If you want to come and give the number, that's fine. It just
No.
seems.
I just want to know.
Okay.
So I just need Mr. Levine's contact information.
It's on your summons and complaint, ma'am. It's
Okay,
on your notice to appear this morning. His name and phone number will be on that document.
okay then. Thank you very much for that.
Bless you.
Anything else in this matter, Mr. Levine?
No, not for me.
Anything else, Ms. Scott?
No, I have his number. I'm fine. Thank you so much.
Thank you, ma'am. Have a good day.
You too. Bye-bye.
Bye-bye. Mr. Cronin,
Yes.
this is 214721 LT. This is West Village Estates versus Raymond Cronin and Tracy Cronin. Sir, will Ms. Cronin be joining us this morning?
No, she no longer resides here. I've been living by myself.
Appearances, please.
Jarrett Levine for the plaintiff. With me is Renee Samples, property manager.
Sir, state your name for the record.
Raymond J. Cronin Jr.
Thank you. Today is the day and time set for the second hearing in this matter. The parties appeared for the first hearing on November 10th, 2021 in this non-payment of rent case. How are we proceeding this morning?
Oh, we have an arrearage. Sorry.
Sorry.
We have an arrearage of rent. It's $1,331.59 plus costs of $199.06 for a total amount due of $1,530.65. Mr. Raymond, at the last hearing, I believe, met with legal service. We haven't heard from Sarah. And I don't know, do you have an ability to get this paid?
I have applied for Sarah.
You have.
Mr. Cronin, do you have your Sarah number?
I do. It's 418-855.
Mr. Cronin, inasmuch as you've made application for financial assistance through the Sarah program, this court is required to stay these proceedings pursuant to Administrative Order 2020-17. The next step in these proceedings is that you receive a copy of the stay from the court, which indicates that stay. If Sarah fails to make payment or indicates that you are not qualified for funding through that program, Mr. Levine's office may file a request for the court to lift the stay and resume these proceedings. Understood?
I understand.
Anything else in this matter, Mr. Levine?
Nope, thank you.
Anything else, Mr. Cronin?
No.
Thank you,
No,
sir.
I'm
Have a
done.
good day.
Thank you. You too.
This is 214729 LT West Village Estates versus Lala Camille Kozikowski and Timothy Kozikowski. Appearances, please.
Jarrett Levine, I'm appearing for the plaintiff.
Catherine Cooper with Lakeshore Legal Aid on behalf of the defendants, P 85148.
Thank you. Ms. Cooper, the court did receive your appearance in this matter. How are we proceeding?
Ms. Kozakowski has applied for a Sarah funding. Would you like her Sarah number, Your Honor?
Not quite yet. I have the wrong file. Give me one second.
Okay.
Your Honor, if I may address the court before we get into the Sarah, there's a companion case, a claim and delivery case.
From yesterday?
Yeah, from yesterday. And
Yes, sir.
I brought that to Ms. Cooper's attention and haven't heard back from her. Honestly, was expecting to hear back from her. I think that's an urgent matter that needs attention. And
I agree,
I'm sorry, you dropped
pursue-
off. I'm sorry, Mr. Levine, you dropped off at the end. You said you were expecting to hear back from her and what?
on what's going to happen with the claim and delivery, because I think we need a global resolution if the lien holder is pursuing possession of that manufactured home for the default on the loan and is in a position to execute and recover possession. Applying for Sarah at this point does not resolve the really urgent case where there's a claim to possession of that home and a pending order where the defendants are not even responding to us or seeking legal assistance to respond to us, yet pursuing rental assistance for this, which I suppose is fine because it'll clear up the site rent, but it doesn't keep them in the home. And I just want to bring that to the court's attention, Ms. Cooper's attention. I think
Ms.
that we
Cooper,
should have a
before you
resolution.
respond, does anyone know where Mr. Kozakowski is?
Mr. Kozakowski is currently in jail for a domestic violence case, Your Honor.
I'm asking only because he's not here. And Ms. Cooper, just so you're clear, yesterday, Mr. Levine was in front of me on a civil docket, and I raised the issue that this case was scheduled for today as the defendants did not appear yesterday. And I had concern about the claim and delivery with the non-payment of rent case today. This court did not receive any indication that Ms. Kozakowski was represented in this matter until this morning, or else there would have been a more involved conversation yesterday.
The appearance didn't come through.
Saying all that to say, I'm
Yeah.
sorry?
I didn't mean to cut you off, but the appearance didn't come through until late. So I don't think any of us knew about it until, and once I got that appearance, I replied to their staff like, yeah, but what about the claim that was up today? And even copied them on the email where we're, attaching that order, because I just want to be transparent about it. Please.
Saying all that to say, Ms. Cooper, I wanted to put that out there before you responded to his comments regarding a global resolution. How did you intend to proceed this morning, ma'am?
Your Honor, I'm in the middle of drafting an emergency. Due to the 56-day rule, I believe Mr. Levine was supposed to file a motion for a hearing before getting an order.
You did.
Because
and it's not, I don't mean to cut you off.
Sir, no. Please do not interrupt her, Ms. Cooper.
So that's what we were intending to do. I was hoping we could get into a breakout room today, Mr. Levine. I know we had a hearing this morning.
May I respond? Just that it's a different court rule. It's 3105. It's a 28-day rule. I did file the motion, and I'd be happy to discuss it with you. Please, before you file an emergency motion, just call me. And maybe it's not a good use of the court's time, but it's not this case. For purposes of this case, I mean, if there's a Sarah stay, there's a Sarah stay. Call me immediately today. Let's discuss that case. And then if we're at an impasse, file your motion. I don't mean to take the court's time any more than that.
No, Mr. Levine, the only other person here is Mr. Katz, and Mr. Katz knows that I'll get to him shortly.
Okay.
Ms. Cooper, the Sarah number for Ms. Kozakowski, please.
It is 431742.
Based on the application for Sarah funding, this court will stay these proceedings. Mary Ann will open a breakout room for both of you if your conversations require this court to pull the file from yesterday and not move forward on the order that was signed. Please advise when you come out of the breakout room. And Ms. Cooper, just so you know, I am a former Lakeshore attorney last year on the EDP docket. So I appreciate you appearing on this docket for the first time.
Thank you, Your Honor.
Mary Ann, you're welcome. Please put them in a breakout room. Mr. Katz.
Good morning.
Good morning. Are you related to another attorney, Katz?
No, probably Jason.
No, it's a female.
Nope.
Nope. Okay.
Why, what's her
Mary Ann
first name?
asked me this morning, she was on yesterday on the civil docket. Mary Ann asked me, I don't know, I don't keep track of that kind of thing. And Katz is a common enough name where you never know.
All right. Not anyone that I know that's related to me, but you never know.
Okay. How are you, sir?
I'm good. How about you?
I'm okay. Feel like I haven't seen you in a while, but
I think it's probably been a month and a half or so.
It was Aaron Katz.
Aaron Katz. I'm
Look
not
at
familiar
Taylor.
with an
She's
Aaron Katz.
fantastic.
I hope she was. I hope she was a competent Katz attorney, because there aren't that many of them.
Well, there are. I used to work for a Katz many, many moons ago. This is 214748 LT Pinewood Circle LLC versus Chantel Miller. Today is the day and time set for the second hearing in this matter. The parties were first here on November 10, 2021, at which time the defendant failed to appear. Based on the defendant's failure to appear, this matter was scheduled for a second hearing where the defendant was directed to appear in person. There is no one in this court's actual waiting room, no one in this court's virtual waiting room by that name. There's no one in the court's on-site Zoom room for these proceedings scheduled at 9 o'clock. It's now 9:43 a.m. by the court's clock. Mr. Katz, based on Ms. Miller's failure to appear, how do you wish to proceed?
Your Honor, at this point, I would like to request a default judgment. As indicated, this is the second hearing. Defendant has failed to appear. Requesting a default judgment in the amount of $2,422, which includes costs of $152. Requesting a default judgment in that amount with the writ to be issued after November the 29th.
$152 in cost, and what is rent?
2422 minus 152 is 2270.
$22.70 in rent, $152 in cost, for a total of $2,422. Plaintiff's office to submit default judgment in that amount based on the defendant's failure to appear for a second time in these proceedings. This is 214755 LT Pinewood Circle versus Carl Rosaboro. This matter was scheduled for a second hearing this morning. The first hearing was on this November 10th, 2021, at which time the defendant failed to appear. Defendant was sent a notice to appear in person for the second hearing. There is no one in this court's actual waiting room. There is no one in this court's virtual waiting room by the name of Rosaboro. There's no one in the court's on-site Zoom room for these proceedings. Scheduled at 9 o'clock. It's now 9:45 a.m. Defendant having failed to appear. Mr. Katz, how do you wish to proceed?
At this point, Your Honor, I would like to request a default judgment. Your Honor, as indicated, this is a second hearing. Defendant has failed to appear for both hearings. At this point, this is a non-payment rent possession judgment case. Defendant has a current balance due of $1,852 of past due rent, $152 of costs, for a total of $2,004. Requesting a default judgment in that amount with the writ to be issued after November the 29th.
Based on the defendant's failure to appear as required for this second hearing, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,852, cost of $152, for a total of $2,004. Plaintiff's office to submit default judgment in that amount. This is 214758 LT Pinewood Circle versus December Dalton. Today is the day and time set for the second hearing in this matter. The defendant did appear at the first hearing on November 10, 2021, received notice to appear this morning for this matter. There is no one by the name of Dalton in the court's virtual courtroom, no one in the court's Zoom room, and no one responding to this matter being called on behalf of Ms. Dalton. Matter was scheduled for 9 o'clock. It's now 9:46 a.m. by the court's clock. Defendant having failed to appear. Mr. Katz, how do you wish to proceed?
Your Honor, at this point, requesting a default judgment. As indicated, the defendant has failed to appear for a second hearing. As of, this is a non-payment rent possession judgment case. As of today, there's a balance due of $2,644 of past due rent, $152 of costs, for a total of $2,796. Requesting a default judgment in that amount with the writ to be issued after November the 29th.
Inasmuch as defendant has failed to appear for the second hearing in this matter, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $2,644, cost of $152, for a total of $2,796. Plaintiff's office to submit the judgment. Mr. Katz, that is all that this court sees for you. Is there anything else you have on your docket, sir?
That is it, Your Honor. Have a good day.
Have a good day, sir. Thank you. Was that sufficient time in the breakout room?
Yes, Your Honor.
And 214729 West Village versus Kozakowski. How are we proceeding in this matter?
Just gonna go with the stay, the Sarah stay, and I'm gonna send some information over to Ms. Cooper on the claim and delivery case. See if we can either access rental assistance funds for that payment or get them into a consent judgment payment plan if possible. At least have that conversation before an emergency motion is filed before the court.
As the parties have indicated, a Sarah stay is in place non-pursuant to 2020-17. The court will send notice of the stay to the parties. Anything else in this matter, Mr. Levine?
Not for me. Thank you.
Anything else, Ms. Cooper?
Not today, Your Honor.
Thank you so very much, ma'am, for joining our docket. Have a good day.
Thank you for having me. You as well. Bye-bye.
Bye-bye. Mr. Levine. In 214773 LT Belvilla versus William Banfield, this court received a dismissal this morning, has signed it. We'll go back downstairs to the Civil Department for processing. 214711 LT West Village Estates versus Kirk Starsky. The court did receive a dismissal this morning, signed it. We'll go back downstairs for processing by the Civil Department. 214694 LT West Village Estates versus James Bevel Jr. This matter is scheduled for second hearing today at 9 o'clock. It's now 9:49 a.m. by the court's clock. The parties were last here on November 10, 2021 for the first hearing. Defendant failed to appear. Defendant was sent notice to appear in person this morning. There is no one in this court's actual courtroom on this matter. There's no one in the court's on-site Zoom room. There's no one responding to the name of James Belville in this morning. Mr. Levine, based on the defendant's failure to appear for the second hearing in this matter, how do you wish to proceed?
I would request the entry of a default judgment of possession. Rent to retain is $1,424.78 plus cost of $164.53 for a total possession judgment of $1,589.31. Proposed judgment read after November 29th unless the total amount is paid.
Based on the defendant's failure to appear this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,424.78, cost of $164.53, for a total of $1,589.31 with a writ to issue November 29th. Plaintiff's office to submit the judgment. Mr. Levine, you have the court's email address, correct?
Civil at 34th District
Yes, sir.
Court.
Thank you.
Yep, you got it.
214698 LT. This is West Village Estates versus Mary Ham. Today is the day and time set for the second hearing in this matter. First hearing was on November 10, 2021, at which time the defendant failed to appear. The defendant was mailed notice to appear in person for this second hearing. There is no one in this court's actual waiting room, no one in this court's virtual waiting room, no one in the court's on-site Zoom room. Defendant having failed to appear for the second hearing, Mr. Levine, how do you wish to proceed?
Requesting a default judgment for possession for a rent to retain of $2,955.05 plus cost of $164.53 for a total judgment of $3,119.58, allowing for writ after November 29th unless the total amount is paid.
Based on the defendant's failure to appear as ordered by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $2,955.05, cost of $164.53 for a total of $3,119.58. Writ date of November 29th. Plaintiff's office to submit the default judgment in this matter. This is 214707 LT West Village Estates versus Daniel Oliver. Today is the date and time for the second hearing of this matter. First hearing was on November 10th, 2021, at which time the defendant failed to appear. Second hearing today scheduled for 9 a.m. It is now 9:52 a.m. by the court's clock. There is no one responding to the name of Daniel Oliver. Mr. Levine, based on the defendant's failure to appear this morning, how do you wish to proceed?
Requesting a possession judgment by default. Rent to retain for this judgment is $1,336.51. Cost of $164.53 for a total judgment of $1,501.04. Allowing for writ after November 29th unless the total amount is paid.
Again, the matter scheduled for 9 o'clock is now 9:52 by the court's clock. Defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,336.51, cost of $164.53 for a total of $1,501.04. Writ date of November 29th. Plaintiff's office to submit the judgment.
Thank you.
This is 214735 LT West Village Estates versus Joel Young and Kathleen Young. Today is the day and time set for the second hearing in this matter. The first hearing was on November 10th, 2021, at which time the defendants failed to appear. Based on their failure to appear, they were sent notice to appear in person this morning for this second hearing at 9 o'clock. It is now 9:53 a.m. by the court's clock. There is no one in this court's actual waiting room, no one in this court's virtual waiting room, and no one in the court's on-site Zoom room responding to the name of West Village versus Joel Young or Kathleen Young. Based on the defendant's failure to appear, Mr. Levine, how do you wish to proceed?
Requesting a possession judgment by default, rent to retain for $1,302.77 plus cost of $199.06, total possession judgment of $1,501.83, allowing for a writ after November 29th unless the total amount is paid.
Thank you. Again, inasmuch as defendants have failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $1,302.77, $199.06, and cost for a total of $1,501.83. Writ date of November 29th. Plaintiff's office to submit the default judgment. This is 214737 LT West Village Estates versus Antonio Dunn, Lamont Walker, and Rua Dunn. Today is the date and time for the second hearing in this matter. First hearing was November 10th, 2021, at which time the defendants failed to appear. Based on their failure to appear for the first hearing, this court would have sent notice for them to appear in person for the second hearing. There is no one in this court's actual waiting room, no one in this court's virtual waiting room, no one in the court's on-site Zoom room responding to the name of West Village versus Dunn, Walker, and Dunn. Based on the defendant's failure to appear for the second hearing in this matter, Mr. Levine, how do you wish to proceed?
I'm requesting a possession judgment by default. The amount of rent to retain is $547.29 plus cost of $233.59 for a total possession judgment of $780.88, allowing for a writ after November 29th unless the total amount is paid.
Based on the defendant's failure to appear for hearing in this matter, default judgment shall enter in favor of plaintiff and against defendants with rent to retain of $547.29, $233.59 in cost for a total of $780.88. Rent date of November 29th. Plaintiff's office to submit the judgment. Mr. Levine, that is the last thing I have for you. But before we go, Taylor, I'd like to say thank you for joining us again this morning. Thank you for the little notes that you leave on my docket. I do truly appreciate it. Anything else this morning, Mr. Levine or Ms. Samples?
Nope, thank you. I appreciate your time and have a nice day.
Thank you. You too. Have a good day. Good to see you again, Ms. Samples.
Bye, Renee.
You too. Bye-bye.
Bye-bye. Mary Ann, that's us. We meet 10 o'clock. Wonderful.
Good day.